segment 410, our last segment on trademarks, enforcement of rights. I'm on page 204 of the textbook. There's two different questions here. Now this is an interesting case that we'll discuss in our lecture, but I want to just highlight a few things with respect to the Lanham Act itself. First off, what was the intent? And this kind of really, I think, pulls together many of the concepts that we have discussed with respect to trademark itself. This is on page 205, quoting section 405 of the Lanham Act. It says, the intent of this chapter is to regulate commerce within the control of Congress by making actionable the deceptive and misleading use of marks in such commerce. In other words, they are trying to ensure that the integrity of marks itself is preserved. And not only that, but it's allowing Congress the right to regulate commerce. And we would say, well, is that right for them to regulate commerce? And I think that we could take a step back and say, by all means, if it helps to preserve this trust between consumers and the company by which they are receiving services or products from, then that allows for consistency within the marketplace. In other words, you would need a government or a party that is large enough to oversee all commerce within a particular jurisdiction to actually regulate them. The second question is, does the Lanham Act allow for causes of actions to be brought by private parties? And the answer to that is yes, absolutely. And in fact, that was the intent here, that if the consumer itself was actually being harmed in any way, that they would be able to have causes of action against the manufacturer of such product or service. Now you contrast that with the other act that is in dispute here in this case, namely the Federal Food, Drug, and Cosmetic Act, the FDCA. Now the FDCA, if you look on page, for example, 206, first full paragraph there, it clearly says that unlike the Lanham Act, which relies on blah, 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 enforcement on private suits brought by injured competitors, the FDCA and its regulations provide the U.S. with nearly exclusive enforcement authority, including the authority to seek criminal sanctions in such circumstances. So with respect to the FDCA, it's the U.S. that would have authority to bring that case. With respect to the Lanham Act, it's private suits that can actually be brought by injured competitors in particular. So, and I would just give one clarification. This is on page 205, the second to last paragraph there. Want to clarify one thing I indicated earlier, namely that the Lanham Act, as far as the private parties that are allowed, it's the private party specifically of a competitor that is being injured. So it's not necessarily just a consumer of it. The mid-paragraph there says, as the court held this term, the private remedy may be invoked only by those who allege an injury to a commercial interest in reputation or sales. In other words, if somebody else is coming along and trying to ride on your goodwill of your name, etc., you may be able to seek compensation and or repair the injury caused by a competitor coming in and in essence trying to seek protection or not seek protection, but just use a similar name within the marketplace. So it's a competitor that is actually being used by use of it's a competitor that's being harmed by use of a similar or deceptive or even something that would diminish the confidence of the consumer within the specific source of the good or product. So let's talk a little bit about this enforcement of rights. So as far as infringement is concerned, again, the steps or requirements to do that, the elements of an action for infringement for trademarks, this is with respect to a registered mark. I'm going to show that there is first ownership of the mark itself, namely that you are the owner of it, that there is some potential alleged infringing use, that it is in commerce, so it's not just something that's private, but it's actually being used in commerce. And then you would show the mark or the similar symbol that's actually being used. And that such symbol is being used with a product and or service that's actually being offered for sale or distributed. And last but not least, the last element is kind of the focus of all this, and that is whether or not there is a likelihood of confusion. And so the basis here in essence is you show your ownership of a mark, and you show the competitor's use of a similar mark, and then you in essence show that there's a likelihood of confusion between the two, between your mark that's protected and the mark that is being put forth by the competitor. So liability here is imposed on one that in commercial advertising or promotion, and this is actually a different branch of, when we talk about the Lanham Act here, this is with respect to infringing use. This next concept is with respect to false advertising. And false advertising specifically looks at whether or not there's a misrepresentation on the nature, characteristics, qualities, or geographic origin of a good, service, or commercial activity. So literal false nature is not a requirement here. So explicit or an implied misrepresentation actually would suffice as far as grounds for false advertising. So if you go back to the concepts of what we're talking about, deceptive use of a mark would be unprotectable grounds. That's similar to what's going on here, that we're trying to protect the consumers from misleading, misdirecting types of marks in the marketplace. And here, if we have explicit or implied misrepresentations in relation to the advertising of a good or service, then again, it would make sense that that shouldn't be allowed as well. So here we have two different companies, the case that you read. We have Minute Maid's company, which is owned by Coca-Cola, and then you have on the right hand side Palm Wonderful LLC, and what they are both selling is a pomegranate blueberry type juice. So on the right hand side you can see that they say it's 100% juice. On the left hand side you can see that they say 100% fruit juice blend. So Palm Wonderful indicates that it's 100% pomegranate juice. Coca-Cola's pomegranate blueberries juice, on the other hand, contains apple grape juice, and 0.3, that's a 0.3% pomegranate juice, 0.2% blueberry juice, and 0.1 raspberry juice. In other words, Minute Maid's brand has almost no pomegranate blueberry juice in it, whereas Palm Wonderful's brand or product has 100% of those two juices. So Palm alleged that it was losing sales because of Coca-Cola's label, namely the 100% fruit label or fruit juice blend label could be misconstrued by those in the marketplace as essentially being the same as Palm's label indicating 100% fruit juice. Coca-Cola indicated compliance with FDCA. So again, this was the Food, Drug, and Cosmetic Act, which looked at whether or not they, in fact, their advertising was in compliance with what it is that they were doing. And Coca-Cola's position was that the FDCA precluded the Lanham Act's false advertising claim. So Palm here was alleging that there was some false advertising going on under the Lanham Act, and Coca-Cola came back and said, hey, we don't even need to get to this concept within the Lanham Act because under the FDCA, we are compliant, and the FDCA in essence would trump the Lanham Act. So the District Court and the Ninth Circuit both actually agreed with this reasoning, and actually then went up to the Supreme Court, and the Supreme Court actually reversed it. And this was back in 2014, and Justice Kennedy said to Coca-Cola's lawyer at oral arguments, "You want us to write an opinion that said that Congress enacted a statutory scheme because it intended that no matter how misleading or deceptive a label is, if it passes FDA, there can be no liability." And that is in essence what Coca-Cola's position was, that we don't even get to the Lanham Act, no matter how misleading or how deceptive the claim is or the label is, because as long as it's compliant with the FDCA type requirements, then that, and again, would trump the Lanham Act. Now, so it went back after the Supreme Court, and there was a wrong spin here because Palm Wonderful was actually under investigation later for false advertising relating to supposed benefits of the pomegranate juice. So what goes around kind of comes around, and in this case, Paul Wonderful was first alleging to Coca-Cola that there was false advertising as far as what it is they were advertising. Coca-Cola came back and said, well, actually, we're in compliance with the FTCA. Supreme Court overruled that and said, well, that's not the case. But then again, the great irony at the end of the day was that, well, Paul Wonderful actually was under investigation for the very thing that, in essence, they were alleging Coca-Cola of.